Good evening. Welcome to Left, Right and Centre. I'm Vishnu Shom. On the programme tonight, it's the legislature versus the judiciary. Once again, following the Vice President's remarks, questioning the landmark 1973 verdict that ruled that the basic structure of the Constitution must be protected at any stage. This has meant that several proposed constitutional amendments, including the recent National Judicial Appointments Commission, have been rejected by the Supreme Court. Now, the Vice President says that the doctrine of preserving the basic structure sets a bad precedent, and it becomes difficult for us to say that we are a democratic nation, a point questioned by many, including the former Finance Minister P Chidambaram. Our first debate tonight, the government versus the judiciary. How will this confrontation end? Later on the show at 1:30, the Home Minister Amit Shah has said that the British have left India. It's time to write history from an Indian perspective. Britishers left India, but history was written through their prism. That confusion persists still, is what Mr. Shah says. On the program tonight, is it time to rewrite our history? Are we fixing it, or is it being changed as part of a new dominant political narrative? But first, the first debate that we are looking at, the Speaker versus the judiciary, Jagdeep Dhankhar, the Vice President of India, and his comments on the judiciary, very, very strident. Let's listen in.
1973 में केशवानंद भारती के केस में सुप्रीम कोर्ट ने बेसिक स्ट्रक्चर का आइडिया किया कि पार्लियामेंट कॉन्स्टिट्यूशन अमेंड कर सकती है पर बेसिक स्ट्रक्चर को नहीं. With due respect to the judiciary, I cannot subscribe to this. This House must deliberate. Can this be done? Can Parliament be allowed that its verdict will be subject to any other authority? When I assumed the office of Chairman Rajya Sabha, in my maiden address मैंने कहा, and I'm not in doubt about it, ये नहीं हो सकता. न तो एग्जीक्यूटिव कानून को देख सकती, it has to follow it, और न जुडिशियरी इंटरवेन कर सकती. यदि अगर संसद के बनाए हुए कानून तो किसी भी आधार पर कोई भी संस्था अमान्य करती है तो ठीक नहीं होगा प्रजातंत्र के लिए, बल्कि कहना मुश्किल होगा, आर वी अ डेमोक्रेटिक नेशन.
सबका मानना है कि विधायी सर्वोच्च कानून बनाने का अधिकार उनको है. जनता उनको चुनकर भेजती है. जनता में विधायी के प्रति विश्वास है. इसलिए जब संविधान ने शक्तियों के पृथक्करण का सिद्धांत है तो हमारा ये मानना है कि न्यायपालिका का सम्मान, उनकी स्वतंत्रता का सम्मान करते हुए हमारी अपेक्षा है कि वह संवैधानिक सीमाओं का और परंपराओं का सम्मान करें.
Well, we've got a fantastic panel tonight. The Speaker targeting the judiciary, the government versus judges. How will this confrontation end? Satyapal Jain, former additional Solicitor General of India and a member of the BJP with us. Justice Madan Lokur, former judge of the Supreme Court, joins us in a little while. Aryama Sundaram, senior lawyer, Supreme Court. Aman Lekhi, senior advocate, Supreme Court. Adil Singh Boparai, former additional advocate general of Punjab and spokesperson of the Congress with us. And Colin Gonzalez, senior advocate of the Supreme Court, all with us. Thank you all very much for being with us. Mr. Satyapal Jain, some of the words used by the Vice President, specifically one-upmanship, public posturing from judicial platforms being done presumably by judges, was not right. He went on to say that these institutions must know how to conduct themselves. Do you believe that the Supreme Court and its judges are incapable of conducting themselves properly?
No. You see, don't stretch it to that extent. See, the Honorable Vice President is a noted jurist of the country who has been in practice for a very, very long time. See, unfortunately, whenever you raise a constitutional or any such issue, people take it government versus the judiciary, government versus the judges and all that. It's not like that. These are important constitutional issues which need to be debated. And he was addressing the conference of the presiding officers, where you are supposed to discuss all these officers. He only says and which has been the matter of discussion in the legal parlance for a very long time. The basic structure of the Constitution, on the basis of which even now the NJAC Act was struck down, has nowhere been defined in the Constitution of India. Right from the preamble to the last article, scheduled and it's nowhere defined. It is something which has been coined by the judiciary. We have all respect for the judiciary. May I also tell you one thing? The media is reporting the statements, speeches of the speaker, the law minister and all that. If you go through the judgment, Constitution bench judgment, 4 judges are on one side. The 5th judge did not agree with them. Can you say that it is judiciary versus the judiciary? No. These are constitutional issues, important issues, which need to be debated and come to a conclusion. One thing more.
I understand that.
Just one thing, just 1 minute. The Indian Constitution starts with we the people of India give to ourselves this Constitution. May I ask a question? Who represents the will of we the people of India?
Okay, that's
only
the
the Parliament. And if you go through the statements of Mrs. Gandhi around 73, 72, 74, she was also by and large speaking in the same tone, which is now being criticized by our own party people.
No, but I don't think it's necessarily Congress versus BJP in quite that sense. It is about our Constitution, how we interpret the role of judges as well. So what Indira Gandhi may or may not have said may not necessarily be relevant, but Colin Gonzalez
would issue has been debated for a very long time.
Sure, no, absolutely. Colin Gonzalez, I think the point that Satyapal Jain raises, and I think that's important, is when one talks about the basic structure of the Constitution, the point he says it's never clearly been defined. So therefore, when amendments or constitutional amendments are struck down, the question that can be raised is you're striking it down on the basis of the special structure, but what exactly is that?
Vishnu, I want to speak very what the Vice President is saying, because he's a little convoluted. So let's be clear what he said. Structure includes 3 things: supreme Constitution and not of Parliament. The Constitution.
All right, 1 second, sir. We'll come back to you. Colin, your audio is bad. Your audio is bad. We'll fix that and come back to you in a moment. Arima Sundaram, same question to you. What Mr. Jain is saying is that the structure, the special structure that we are talking about hasn't really been defined. The basic structure. This being the case, is the judiciary on difficult ground?
Look, the basic structure of the Constitution is found from the preamble of the Constitution. It is found from the very basic fact that we are a democracy. We are a secular democracy which has assured liberty, fraternity to all the people, equality. So anything which departs from these would depart from the basic structure of the Constitution. One of the integral factors, one of the integral parts of democracy is what is known as separation of powers.
Yes.
And this separation of powers is absolutely vital, where the legislature, the executive, the judiciary, each have their roles to play. The role of the judiciary in every country, be it the United States, be anywhere else, has been as a watchdog to protect the Constitution. When the legislature may, even in its wisdom, do something which otherwise goes against what basically the Constitution stands for, it's the duty of the judiciary to step in. That is the basis of separation of powers. And nobody will doubt that separation of powers is itself the basic structure of Constitution, because separation of powers itself is the basis of democracy. So I think we can glean very easily what is the basic structure. The basic structure is the guaranteeing equality, fraternity, liberty, and a democratic, secular democratic republic. This is the basic structure of the Constitution.
So that's the bottom line, and Parliament can't change that.
Towards this is towards the basic structure.
No, so Satya, Mr. Jain, so this is the key point. You say that it's not been categorically defined, the basic structure, but what Arima Sundaram says is it has been defined. It's the heart and soul of what the Constitution presently is. So
see,
therefore,
I agree with Mr. Sundaram. if you see the constitution, the first line says, we the people of India. Now the question is, who represents the will of the we the people of India? It is the parliament. It is the elected representatives. Now NJAC Act was enacted by the parliament for the first time in the entire Indian judicial and parliamentary history unanimously. Lok Sabha, Rajya Sabha given assent by the President of India. I put a question to myself. By enacting this law, which fundamental structure has been violated? Which principle of law has been violated? How do you say it violates the basic structure? If people of India want that instead of judges appointing the judges, let the judges be appointed by the National Judicial Appointment Commission, which is also dominated by the judicial people. How does it violate the basic structure? Which basic structure? Preamble, any article and all that. The basic structure, as Mr. Jagdeep Dhankhar has said there, the basic structure is the will of the people. Any basis of any structure has to be the people who are holding it. So will of the people is the basic structure.
Okay.
You can't annul the will of the
All
people.
right,
by
Aryamaa
saying,
Sundaram.
I don't agree with that.
The will of the people is represented by those who sit in parliament. If their will is something that has to be respected, the courts need to do that.
Look, the essence of the country, the sovereignty of a country, people have to work towards not the will of parliament. The will of the people is already represented in the constitution, through the constitution. The constitution represents the will of the people. It can never be a majoritarian intention is the will of the people. The country's will is expressed through its constitution. And something which militates against the basic structure of the constitution, therefore militates against the will of the Indian as a whole. Not Indians as individuals, but India as a whole. And India as a whole, its will is stated in the constitution. And that's the importance of the basic structure.
No, but sir, if we talk about NJAC for just a moment, in fact, I wanted to go across to Aman Lekhi for that. You know, you can question, you can criticize the judgment, you can share your views on it, but the basic point is, if a Chief Justice, 2 judges, a law minister and 2 eminent citizens decide who the judges are, it could be problematic because the law minister is part of the government. The 2 eminent citizens may or may not be disposed, transparently. So therefore, the existing system, it's argued, works. So what is wrong necessarily with the judgment saying that NJC couldn't go through? What was wrong in what the Supreme Court said? Mr. Lekhi.
Well, Vishnu, 2 things. First, I'll flag the unruliness of discourse, which I think is a very disturbing phenomenon right now. There's a blame game on, and that in some way affects constructive engagement, because if the comments are persistently ad hominem, we have the law minister, now we got the vice president, you got the speaker. There's no harm in debating basic structure, but then you can't say on the guise of debating basic structure that what the court does undermines democracy and present a rather dreary picture of the future because the court is doing its job. So this in some way puts into focus the motive behind the comment rather than the comment, because the attack is on the people and not the issues. So I'm against this method, firstly. Secondly, Mr. Jain has said, where is basic structure? Now, that is precisely why basic structure is there, so that no one can actually say there's no basic structure. And that's the reason why basic structure is there, because embedded in the concept is controlled constitution and division, and a balance, that is an interdependence of institution, which is actually recognized as basic structure, because what it actually says is that there's no hegemony of one institution. Now, what this particular comment is saying is parliament is supreme. Now, it is essentially to rein in the parliament that you have this particular system where the court, while conceding to the parliament, is very pertinent. Basic structure doctrine acknowledges the plenary power of parliament. In fact, the occasion was a restrictive interpretation of what the parliament could do. With the Supreme Court, Justice Bharti said, no, you can't stop the parliament from doing anything. The parliament's power as plenary, it can also in some way override the fundamental rights. It went to that extent.
Right.
But you cannot damage the identity of the constitution. Now, does Mr. Jain not know the identity of the constitution? Is there any confusion about what the constitution means? Is there any confusion about what the constitution stands for? Are we going to quibble about what the fundamental values on which our polity is based? can anyone say that we do not know what is the basic foundational structure of our constitution? Now, if you are going to in some way doubt that, and the guise of doubting that, assume to yourself the plenary power, you are going to in some way end the control with the constitution envisages, do away with the balance, and vest the hegemony in one institution so as to in some way distort the system of the whole. And if you look at the history of developments, we may talk about NJAC. I have my personal reservations about NJAC in the sense that I feel the judgment could have been different, it could have been done, but that doesn't necessarily mean I'll start doubting basic structure. Because in so far the basic structure is concerned, the number of times that has been used, whether it is what Mrs. Gandhi did to amendment insofar as the elections of the Prime Minister are concerned, whether the subsequent involvement insofar as the 368 amendment is concerned, the Supreme Court has always intervened to check abuse of power. That is where basic structure becomes important, to check abuse. And abuse is essentially to preserve the essence of what our constitution...
Okay. Mr. Lekhi, I get all of that, and I want Mr. Jain to respond. I think the first part of what was mentioned by Aman Lekhi is the language which is being used now. Replies certainly to what Aman Lekhi is arguing, but also, sir, the use of language. If the Vice President says things, for example, he said this in the Rajya Sabha last month, the Supreme Court compromised parliamentary sovereignty, disregarded the mandate of the people, right? Parliament has the right to enact a law, but the power to scrutinize it lies with the court, etc., etc. And today, much stronger, one-upmanship, public posturing from judicial platforms. Has he not crossed a certain threshold which we've not seen before?
I think don't take it in that sense. Don't take it that way.
So there's a history of remarks. That's my point.
Which is, please try to understand. The point that is being underlined and the point which is being raised is not being raised for the first time. We know it very well for a very long time. Even among the judiciary, this issue is being debated. See, I agree with Mr. Aman Lekhi. There is a basic structure. There is a basic features. But the question that rises is, when you strike down an enactment of parliament saying it violates the basic structure of the constitution, a question is put to the person concerned, which basic structure it has violated. There is no question of infringing upon the power, separation of power, parliament supreme in its own field, executive in its own field, judicial in its own field. You are striking down a particular act. On the ground, it violates basic structure. Now the question is, which is the basic structure that it has violated? How does it interfere with the working of the judiciary? Is the judges being appointed not solely by the collegiums of High Court and Supreme Court, by a commission which consists of primarily all the judges, Supreme Court also, High Court also, retired judges also, only one person, law minister, who ordinarily is also a law graduate. Ordinarily, I'm saying that the will of the people, ultimately the basic structure, basic feature is, in a democracy, it is the will of the people that prevails. If it violates any particular section, article, for example, it violates Article 14, 16, 15, the court will be justified in striking it down.
Okay.
But when you are not pointing out...
Mr. Jain, I will come back to you in a moment. Justice Madan Lokur is just waiting for us, so I wanted to quickly go across to him. Justice Lokur, one of the points mentioned by Mr. Dhankhar last evening, and I quote, can Parliament allow that its verdict will be subject to any other authority? Otherwise, it will be difficult to say that we are a democratic nation. How would you respond to that, sir?
Well, I think it's very well settled for more than 200 years that judicial review is a part of a democratic process. That is to say that if the legislature violates the constitution, then judicial review permits the courts to strike down that legislation. This was, said more than 200 years ago in the United States Supreme Court, and we have also followed that, right? So, if a law violates the Constitution, of course it has to be struck down.
No, but sir, I think the point, Justice Lokur, is if the government in power, whoever has the numbers, feels that in itself has to change. For example, the word secular, and there's been such an extensive debate in this country around its use. And if there are political parties who question the use of the word secular, and it's come out time and again, and they want to, for example, remove it, in the present system they can't, because the judiciary would likely block it. And therefore, the argument is, if we've come to power, why can't we change what we want? How does one respond to that?
Well, you can change what you want, provided you do it according to the Constitution. Now we are a republic, right? Can it be said that we can do what we want, so we'll convert India into a monarchy? We are a democracy. Can it be said that because we can do whatever we want, we are going to declare India to be an authoritarian state? I mean, there's the Constitution is there, so you can do whatever you want subject to the Constitution.
So Justice Lokur, what is this debate actually about? Is it about changing the fundamental identity of India? Because it seems to be much more than talking about the law, right? We aren't talking about the law. We aren't talking about what parliamentarians do. We're talking about something larger. What is that, sir?
Yeah, well, your guess is as good as mine, and I don't know where we are heading, where this discussion is going to end.
Do you believe that it is dangerous, Justice Lokur, for us to be questioning or debating the basic structure? The basic structure is the wall, right?
Yes.
Why is it dangerous, sir?
Well, it's obvious. I mean, there are certain things which form a part of the basic structure of our Constitution, right? For example, the Supreme Court has said that free and fair elections are a part of the basic structure of the Constitution. Okay. Now, if you say that there is no basic structure, are you trying to say that rigged elections are also all right? You don't need to have free and fair elections. Independence of the judiciary, that's also a part of the basic structure of the Constitution. Are you trying to suggest that no, we don't need an independent judiciary? We'll have our own guys sitting in the Supreme Court. So the basic structure has some meaning, and Parliament can't do whatever it wants to do, just because it feels like it. There are provisions in the Constitution where you need 50% of the state legislatures to agree with an amendment to the Constitution. Can Parliament say that, listen, forget it, we don't want this provision, so we amend it and forget about the states? What happens to the federal polity? So really, this direction of the debate is a little scary.
Justice Lokur, you're welcome to stay on in the debate. You wanted a one-on-one interaction, but do stay on if you like. Adil, can I just go across to you, because the Congress party believes that this is a larger issue. It's about changing what our India is, right? And in as much as the Congress is entitled to have that view, there are many who would suggest there is a lot in our country that needs to change, and that we are in the middle of a churn. And therefore, if the BJP, which is dominant in Parliament with the numbers, wants to start a process of change, whether it's laws or anything else, you really shouldn't get in the way. I think that's what this is all about. Adil, how would you respond to that?
Vishnu, the Honourable Vice President is wrong. I repeat, the Honourable Vice President is wrong. It is the Constitution of India which is supreme. And the basic structure doctrine is a protective shield against legislative and executive excesses and tyranny. The essence of the basic structure doctrine is the power of judicial review. Of course, Mr. Jain is right. It is the power and the duty of the Parliament to legislate. But that does not mean that the judiciary cannot interpret the law made by the Parliament and judge it by the parameters that whether it is in conformity with the Constitution or not. That is the work of the judiciary. That is the task which is cut out for the judiciary. And there have been repeated assaults, Vishnu. There have been repeated assaults at the behest of the BJP and the RSS to weaken the judiciary. And it is extremely unfortunate that the Vice President has joined this chorus. This country was known for its robust institutions. Today, what you see is a near or a total capture of institutions. And their next target is to emasculate the judiciary. You have a pliant media. You have the EC under your thumb. You have the bureaucracy which has become spineless. And let me be blunt. The former judge of the Supreme Court eloquently put out what the judiciary and what the constitutional framework is, but let me be blunt on behalf of the Congress party. The objective of the BJP is to place yes men in the judiciary.
All right. Okay. So that's a pretty strong. That's a pretty strong.
And finally, Vishnu.
That's a very strong allegation, and I think Adil, respectfully, without any evidence to that effect. I mean, you can question judges and say that this judgment seems strange or that judgment seems strange, but that's a pretty strong allegation.
I will give you an illustration. I understand your anxiety. I'll give you an illustration. There have been repeated examples in the past where the Supreme Court Collegium has sent names to the government, where it is reiterated names for elevation to the government, yet the government is sitting on those files. What does that mean? That means that the government is not comfortable with
all right. So, and that in a sense is part of the initial problem, the process of selecting judges. Mr. Jain, couple of points that he mentioned over there, but also would you like to react to what Mr. Chidambaram said, where he said that the basic structure was evolved in order to prevent a majoritarian-driven assault on the foundational principles of the Constitution.
I'm very happy that Mr. Chidambaram has now realized that. And he represents a party which not very long time back in 1975 threw all democratic conventions, constitution to the dustbin and imposed emergency in this country and passed laws in the absence of the opposition. And it was these people who superseded 3 judges of the Supreme Court to appoint, I don't use the word yes men, no judge is yes men. When you say you want to appoint yes men as judges, you are insulting the entire judiciary. You are insulting the entire judiciary. No government can appoint a yes man. No, we never appointed it. But don't forget, it was your party in 1975 when you superseded 3 senior most judges of the Supreme Court to appoint a 4th person as the CGI. What were your factors? You know it better. BJP, central government, Narendra Modi government, we believe in the Constitution of India. Constitution is supreme. We believe in the separation of powers. But all the 3 have to confine to their own field. Constitution is supreme. The question which I am putting and I am not getting an answer is NJAC Act violated which provision of the Constitution of India?
Okay.
Which provision of the Constitution of India? Which basic structure? You can strike down a law if it violates Article 14, Article 19, 356, whatever it is. Simply you use a coin to strike down an act. I think this is something which needs reconsideration and I am very happy. I'm very sure after 10 years, the Supreme Court, as usual, have been overruling its own judgments. After 5 years, 8 years, 10 years, a time will come when Supreme Court itself will review its own judgment and agree with the dissenting view, not with the majority view.
Okay, Colin Gonzalez, we've got your line back. I hope it's clear. How would you respond to that?
Well, let me just say a few points to make the language of what the Vice President has said clearly understandable. He is against 3 things because basic structure, 3 main things. Supremacy of the Constitution, not of Parliament, secularism, and the third is the independence of the judiciary. And our Vice President, who occupies his position under the Constitution, is ferociously opposed to all 3. Let me explain that. Parliament supremacy has never been there. And democracy after democracy in the modern world doesn't have Parliament supremacy. Parliament supremacy, when he says that, is a very dangerous thing. What it means is a particular party comes to power today, some other party comes to power tomorrow. Somebody comes with majority and says, I'm going to make a law. Let's suppose I'm in Nazi Germany. German parliament has elected Hitler, and I'm going to make a law saying that all Jews will be denied citizenship. Parliament is supreme. Might is right. Majority wins. And what do you have? Fascism. That is why the Constitution will keep you within bounds. You can't be arbitrary. You can't be discriminatory. You have to be rational and all the things that the Constitution prescribes. And what the Vice President says, I don't want any of these limitations. I should be allowed to make any law I want to make, and I don't want the judiciary to dare interfere. That's the first point. On secularism, very interesting now, this secularism is linked to this fight over judges. Keshavanandi Bharati and S.R. Bomai's case says, secularism is the spine of the Constitution, basic structure. 11 judges said that.
Yes.
Now you have to overturn that, to bring in Hindu Rashtra, to say that Hindus will have a special place, minorities will be diminished, and you have Hindu Rashtra, not India, not constitutionally run India. You'll have Hindu Rashtra. You have to overturn Keshavananda Bharati. He made specific reference to that. That is why you need to pack the courts with as many saffron judges as you possibly can, meaning thereby judges who are indebted, aligned to, politically in agreement with the government at the center.
Okay, let me get a response.
This is why you're having this fight over
I need to balance this out. I get your point.
One more thing, one last thing.
No. I got to interrupt you there. Let me get a reaction. Satyapal Jain, would you like to respond to that? Again,
I think my friend is taking his brief to a very large extent. There is no question of anybody declaring India as a Hindu nation or Hindu Rashtra or amending the constitution to take away fundamental rights and all that. I don't say, the Vice President doesn't say that the Supreme Court doesn't have the power to decide as per the constitutional mandate. Nobody is saying that. I don't know why everybody thinks of Hindu Rashtra language and all that. Mrs. Gandhi made all possible attempts to do the same thing in 1975. And this country had the power and the capacity to come out of that crisis. India can never allow anybody to be theocratic. India has never been theocratic. When the word secular was not there in the Indian constitution, were we not secular? We are secular throughout. Sarv Dharam Sambhav, Vasudev Kutumbakam, that been our ideology right from day one. जब से दुनिया बनी है तब से हमारा ये विचार रहा है. तो हम secular का word use करें ना करें, it doesn't make us secular or unsecular. I am requesting him, take the positive view of the matter. Don't take things always in the negativity to such an extent कि पार्लियामेंट का अमेंड हो जाएगा, पावर चली जाएगी, हिंदू राष्ट्र हो जाएगा. कुछ नहीं होता. मैं फिर कह रहा हूं, NJAC एक्ट को बेसिक स्ट्रक्चर की वायलेशन के खिलाफ which clause
okay,
of the
let's try and get an answer to that or a
which
view on
basic
that.
Structure has been violated.
Arima Sundaram, would you like to? Mr. Jain has mentioned this 3 times. What was wrong with the NJAC? How is it against the basic structure? How would you respond?
Look, fundamentally, I believed that the concept of the NJAC was not bad at all. And it was something which could be a representative body, a collegium to choose, which could include someone like the Prime Minister who would definitely be looking for the welfare of the country, leader of the opposition. You could have had members of the judiciary. But the error in the NJAC Act as it was that it gave the supremacy to the executive in the selection process. It allowed a veto to the law minister and said very clearly that without his approval, nobody could be appointed. I feel if the supremacy, if the finality of a decision could have been left to the Chief Justice, to the judiciary, we could have had a representative body choosing judges, and that could have been good. But it should have been very clear that in the event of a disagreement, then the view of the judicial members is what would count, and a tiebreaker, so to speak, would be the Chief Justice. I feel
so
if it had been done that way, the NJAC could have worked.
The lack of a good judge
but
for that
making the executive the supreme authority, violated the separation of powers.
All right, look, gentlemen, it's been a fascinating debate.
May I add just one word? Before this judgment, 1903 SP Gupta's judgment, who appointed the judges? It was the government. And judges like Justice Krishna Iyer, and I can name 101 judges who came from that system and proved to be one of the best judges of the country. Therefore, don't say simply because somebody has been appointed by the executive, he will not be independent, and simply somebody has been appointed by the judges will be independent. Don't say that.
Okay.
We have both the
All
systems
right.
during the last 50 years.
Okay.
Both have worked very well.
Okay, all right. We will try and revisit this at a later stage. I'm out of time. I'd like to thank you all very much for joining us.